Welcome everyone. We are live with a brand new episode of Level Up Law. Every Tuesday at noon, South Carolina Legal Services levels up your legal knowledge about an area of law that we practice in, and we're delighted to bring you today's episode on federally subsidized housing with our housing law unit head, Matthew Billingsley. I'm Susan Ingalls, Senior Staff Attorney and host of Level Up Law, and as always, our producer, Kenneth Elliott from our IT department is here making sure everything is running properly for us today. Kenneth is fresh off the Innovations in Technology conference that Legal Services puts on every year, so welcome back, Kenneth. And you are viewing Matt Billingsley, attorney from our Charleston office. As I mentioned, Matt is the head of our housing law unit here at South Carolina Legal Services, and he's with us today to provide a brief summary of what we're talking about when we refer to federally subsidized housing. But before that, we do want to always remind you that this is not legal advice. It's just general information for the public, but it is important information and hopefully it is helpful to you. But if you need the help of a lawyer, do call our intake line here at South Carolina Legal Services, or you can apply online 24/7. That information will be provided for you at the end of today's presentation. And also, as a quick reminder, all of our episodes are posted by producer Kenneth Elliott to the Level Up Law playlist on our YouTube channel, usually within about 24 hours. For today, and Matt's presentation, he can answer general questions if there's time, of course, at the conclusion of today's presentation. So just put any questions that you have there in the question box. There's a question box and a chat box. The chat is for chatting with us if you're having any trouble that Kenneth needs to help you with connecting to the episode, and then the question box is for you to throw out some questions to Matt if you have one. So with all of that having been said, Matt, let's get started. I'll turn it over to you.
All right. Well, thanks, Susie. And as you said, I'm Matt Billingsley in the Charleston office. Talk about subsidized housing or general kind of information and overview really about what it is. So today that's what we'll be going over, kind of what subsidized housing is, how to recognize it, and some basic information on it. We're not really going into things like actual evictions or that kind of issues today. So we'll just go over the basic information. Give me just 1 second. Let me get that. Okay, so federally subsidized housing. We're going to primarily go over the basic 2 most common types that you'll run into or that you see. One thing to keep in mind is there are a lot of different subsidies, and what that really means is that the housing is partially funded in some way by federal funding or some kind of tax break or something like that. There's a lot of different kinds of it, and so we're not going to go too far out into the weeds of all the little different ones that there might be. We're going to focus primarily on the 2 most common ones that we see. So those are generally public housing and Section 8 vouchers. We're going to go over like how that federal law kind of impacts the Residential Landlord Tenant Act, where you see SCRLTA. That stands for the South Carolina Residential Landlord Tenant Act. That is Title 27, Chapter 40 in the South Carolina Code. Other federal laws kind of come into play when you have this meeting of federal issues along with state housing laws, and that's public housing in Section 8. We'll just go jump right into it so federal law applies in courts in South Carolina and state courts. It's sometimes people get confused on that. I've seen even people that shouldn't get confused on that, but it does apply in state court. As we say, the law or the regulation that offers the tenant the most protection will apply. That generally comes from the federal regulations that say, you have to follow state law along with federal law when dealing with this kind of subsidized housing. And if one or the other gives the tenant, I guess, gives them a better benefit or higher protection, then that's the one that should control. That would be, for instance, if the state law only provided a 14-day notice, but if federal law provided a 30-day notice, that 30-day notice would apply. So whatever benefits the tenant the most is what the law says applies when you're dealing with these. So dealing with public housing and what they call true public housing is a federal housing program that really where the housing authority or public housing authority is the landlord. They are the owner of the building, and it's set up under the public housing program. It originated with the U.S. Housing Act of 1937. You have to be less than 80% of the area median income, can be as low as 30%, but the rent is generally 30% of the tenant's adjusted income, and the minimum rent can be up to $50 a month. So a good way to look at that is your rent that you're paying is usually just a little bit under 30% of your adjusted monthly gross income. You do get a credit for utilities. There's an amount that's taken off on that. So, and there's no need to go into those too much in those details for the calculation. It gets a lot more complicated to actually figure out what rent a particular person would have. But the hallmarks are your public housing authority is they are the owner and running the apartment complex as the landlord. So it's funded by HUD, annual contribution contracts. The local, when you see PHA, that's referring to a public housing agency, public housing authority. There are lots around. I can give you an example. There's some of them are city housing authorities, some are county housing authorities, some are also regions in areas where that may not have as heavy population. But the federal law that governs it, you see down there, is 42 USCA section 1437. When you see the CFR, the Code of Federal Regulations, those are regulations that kind of further explain and lay out the rules here for public housing and for subsidized housing. In 24 CFR 960, 966, and so on are ones that are really important and give you all the rules. One that you'll see coming up soon is going to be 24 CFR 966.4, and that's probably the most important regulation to look up or to be aware of if you're in public housing. It gives you a lot of good information there. As you see, like, housing authorities are created, like I mentioned, they're created through the state, and the state outlines how they can be created, but they generally can be just, through a city, a county, a region, anything like that. As you see down there at the bottom, the 966.4 talks about lease requirements, but also includes a lot of other information. It's kind of a long regulation, but it's got a lot of valuable information about what the rules are for each tenant and the housing authority. So again, as the housing authority is the landlord, then we look at how is it different from the Residential Landlord Tenant Act. You'll hear the term, and when you participate in public housing or you're given information in your lease or something related to it, you'll see things or in a policy manual that housing authorities have. They do have to have a policy manual on public housing. And you'll see the term grievance or grieving them or something. So if you want to dispute or raise an issue that you want to challenge in some way, then there's a process for that. Usually you can request that, say if they, one of these examples, if they say they want to terminate your lease, or they want you to move for a certain reason, you could request a grievance hearing and go through, and that's an administrative process. But another thing to look at is tenants get 14 days notice for non-payment of rent, usually in public housing, so sometimes you get a little bit longer. State law is just 5 days, provided that the notice is in the lease. Some other notices can be the same. what you usually look for is consult your lease. That's one of the things to keep in mind with any of these. A lot of times the public housing lease or even other subsidized housing leases have requirements of what to put in there. And so a lot of information and good information will be in the lease. And sometimes if it's a different type of housing or subsidized housing, it will usually reference that in the lease itself. So it's always good. Check your lease. Don't set it to the side and put it in a drawer somewhere and forget about it. It's got a lot of valuable information, and it can really help you to understand what's going on when you have any issues with the landlord or housing authority. Okay, so for housing authority and public housing, a notice, for instance, a notice to terminate has to give the specific grounds for that action. Why are they doing it? You're right to examine the housing authority documents, which is usually what documents they're relying on for that action, or they'll put those a lot of times in a tenant file. The right to have a grievance or to grieve them on that issue, and also the housing authority's right to exempt a particular issue from the grievance process. That usually comes from the regulations that we talked about a little bit ago, that in certain times or certain things, the housing authority doesn't have to give you a grievance opportunity or a certain notice due to the nature of the allegation. Usually that's with pretty severe issues and dealing with evictions. The term good cause there in the last bullet point is always required to evict in public housing. Housing authority cannot just decide to end your lease. That's one big and major difference in subsidized housing versus private landlord tenant housing. In your regular everyday private landlord tenant, when your lease is coming to an end, the landlord might say, or if you're on a month-to-month lease, they give you a 30-day notice, say we're not going to renew, we just want to move on for whatever reason, and they can do that. In the public housing setting and in most subsidized settings, they cannot. They have to have a good reason or a cause to actually put you out, and that's a really important thing to keep in mind. You might find property managers or someone who's managing that property for the housing authority that may not understand that fully, but so it's good to know your rights and know what they have to do there. Okay. So what is good cause for an adverse action in public housing? Again, as I said, it's showing up in 966.4 L2, but it's a serious or repeated violation of the lease. Tenant could become over the income limits if you start to make more money where you then become over the income limits. The idea is to get you to be able to move off of public housing. Other good cause is not always defined out too well, but it seems to be something that maybe state law includes, but maybe that the federal law didn't really anticipate or think about. Criminal activity and alcohol abuse are things that can also come into there. Conviction for meth production, manufacture of meth on premises, drug-related criminal activity on or off the premises, threats to other residents, allowing a fugitive or someone to stay with you, pattern or alcohol abuse or something like that threatens health and safety. One key you'll see here with a lot of these things is they're things that are done, but that they affect what's called health and safety, and sometimes right to peaceful enjoyment of other tenants or residents. And so usually there's that health and safety aspect kind of attached to a lot of these things. If they later discover that you actually were ineligible to be on public housing, the discovery of if you've made false statements or any fraud by the tenant related to their income. So if the tenant lies about how much their money is or what their income is, because that affects how much they're supposed to be paying. Failure to comply with community service requirements or refusal to accept a new lease when they give it to you. So every year in public housing and a lot of subsidized housing, you recertify where they check your income and make sure everything would stay the same, or even if not, you sign a new lease. If you don't do that, they can have an adverse action against you and move to terminate that. Community service requirement for public housing, they have to complete about 8 hours community service per month unless you're exempt. So exemptions listed there below that makes sense. Over 62, blind or disabled, primary caretaker of someone who's blind or disabled, If you are working or participating in a welfare to work program, or if there's any other specific exemption, and notes there the regulations that cover that. But otherwise, you have to do the community service requirement. So that's kind of a basic overview of public housing and what to understand or know as the kind of touching the surface of public housing. Section 8 is a different program, but it's very similar. The difference though in Section 8 and what breaks down to Section 8 is you'll see in the first part where it's talking about an umbrella of many programs that include a voucher program, a project-based voucher program, new construction, and all these other things. What really you need to think about is the housing choice voucher and the project-based voucher. So project-based voucher, you're really looking at very similar to public housing, except a private landlord is kind of acting in the place of the housing authority. They are running the whole apartment complex, and all those apartments or units in the housing complex are subsidized. And the subsidy, the amount of money that the government pays or HUD pays on the person's behalf is tied to that apartment. But with a housing choice voucher, the subsidy is attached to that person. They can pick up that subsidy and go to stay at any private rental, whether it's a home, apartment, or anything, and kind of take the subsidy with them. And that's the main difference there with that. So eligibility, as you see, kind of the same things as before. And you can't, pay more than 40% of your adjusted monthly income, but that really comes into where there's a whole other thing to deal with as far as the amount of rent that's being charged or the amount of rent that's allowed to be charged, say in these private rentals where you're taking a voucher to it. So the housing choice voucher, it's common. It's something that a lot of people can get mixed up on because there's this kind of split thing where you're dealing with a housing authority in that situation and you're also dealing with a landlord as opposed to them being together. So the housing authority for your housing choice voucher is not the landlord. What the important parts to know about that is your landlord for a housing choice voucher is just your private landlord that you're dealing with as any other private landlord and tenant would. You deal separately with the housing authority about your income, how much you're supposed to be paying, recertifications, and any issues that might come up where they try to terminate your voucher or tell you they can terminate your voucher. But that is one of the main things to keep in mind regarding that. So PHA is certainly not a payment standard for your local jurisdiction. So here's where it gets into a little bit about finding that place, that private rental to take your voucher to. It usually, they put out what those rent standards and payment standards are. It's usually between 90 to 110 of the fair market rental value in the area. So that's something to keep in mind. It's something that you have to also be aware of what HUD says the fair market rental value is, and maybe what the market is actually charging or what you can actually find. And that sometimes does create a little bit of an issue. They also perform a rent reasonableness evaluation and determine the landlord if the rent is appropriate. Essentially what they're doing is when you're getting a housing choice voucher and you're taking that to a private landlord, that landlord who agrees to take the voucher they are also having a contract with the housing authority about what they can do, how much they can charge for rent, what's approved and what's not approved, and things like that for the payment and the amount. Okay, so it also lists the U.S. code and the federal regulations and the parts that deal with vouchers and the parts that deal with. So 982 with vouchers, 983 with project-based. Part 5 just has HUD programs generally that kind of applies to all of them. So, and it varies what housing authority kind of administers those particular vouchers for which areas. So that is one thing you also have to pay attention to: what area you're moving to, what area you're going, or where you're getting the voucher from. So vouchers, As I just said, it's between three parties. It's you and the landlord. It's also the housing authority as well. So if you get a voucher, now the one thing that keep in mind is vouchers can be difficult to get on a waiting list for and to eventually get a voucher. It's not something that is just go right up and just get your voucher right away. So it's something that people have to plan for, or maybe even look at other housing options while they're waiting on that voucher, waiting on a waiting list or something like that. But you have to find your own housing once you get that housing choice voucher. They sign a HAP contract, as I mentioned before. That's that contract that the housing authority signs with the private landlord that sets out a lot of their agreements of what they can do, what they can't do. And then you have essentially a regular lease with the landlord. You have to comply with the terms of the voucher and requirements of the program. You have to comply with the lease as well. So you have kind of two things going there. There's a mandatory HUD lease addendum that's usually about paying the rent and your portion of the rent. That can change obviously as your income changes. So that's something that usually you have to pay attention to. But the housing authority notifies both parties when that does change, of how much rent you have to pay when that is, and then the amount that the housing authority is paying. So owners have to comply with the terms of the HAP contract with the housing authority. So they have to keep it within housing quality standards. What that really gets down to is that the housing authority has a little bit of leverage against the owner or the landlord to make them do repairs. And that if they don't do repairs, they do have the power to hold back their portion of the rent. That does not really apply to the tenant. However, the tenant is responsible for paying their portion of the rent, not the housing authorities. But the landlord has to also comply with the terms of the HUD addendum, which goes into the rental amount. Housing authorities have to, of course, comply with the federal law and their regulations. They have to also make sure that both the landlord owner and the tenant and participant are following what they're supposed to do. So generally, you do have an option for a grievance or an informal hearing when there's a proposed adverse action, meaning they want to terminate your voucher, usually by the housing authority. So notices have to specify the grounds for that action, give you, again, the right to examine the documents, the right to do the grievance, and whether or not that particular issue is exempt from a grievance process. But when you're talking about a voucher, a housing choice voucher, you're always entitled to, you're just about always entitled to an informal hearing process to be heard on that matter by a hearing officer. The reason for that is due process. They have to give you some form of due process because it's not like in the public housing setting, you would go to, they would go to court just like a regular landlord would to do an eviction. But with the voucher, if they didn't have this process or informal hearing process, you wouldn't have any other due process. So that is one thing to keep in mind. You can't always challenge that. The landlord cannot evict if the housing authority abates rent. And what that means is what I referred to before. The housing authority, what they'll do is generally, and I mean, COVID times were a little bit different, but they will inspect the apartment to make sure that the landlord's keeping it in good working order, keeping everything working or repaired that they're supposed to. If not, they notify the landlord that they have to fix some things and bring it into compliance. And they'll come to re-inspect. If the landlord doesn't do that, then the housing authority can say, okay, we are going to abate the rent, which just means they're going to withhold their portion of the rent until the landlord fixes it. The landlord still doesn't fix it, then the housing authority can give the tenant, the participant, they can terminate the contract, essentially terminate the lease, and allow the person to move somewhere else. It's a powerful tool, and it does offer some assistance when a tenant is having difficulty with the landlord getting repairs to be made. The landlord can, though, evict if you don't pay your portion of the rent. So if a tenant doesn't pay their portion, so they're not responsible for the housing authority's portion, only theirs. So the landlord can't file a case, go to the magistrate court and say, I want to evict this tenant for not paying the housing authority's portion of rent. They can't do that. You usually have to have good cause during the lease term, but at the end of the lease term, even though they have a voucher and a HAP contract, they don't really have to keep it going necessarily. There might be a little bit of some argument there as to what they can and can't do, but it's generally accepted that they can't, or they can in the lease just treat you like a regular private landlord tenant situation. All right. What is good cause in Section 8? And as I said before, it's not really defined, and other good cause is not defined in the best way. Good cause in general just refers to that serious or repeated lease violation. One example that comes up a lot is drug-related criminal activity that's on or near the premises, and this is for Section 8 as opposed to public housing. Only on if the actor is not the tenant or tenant's like household member or guest. If somebody's there as a guest or someone under your control, then it matters what they do on the property, not necessarily what they do off the property. But for the tenant or a household member, it's on or near the premises. Some housing authorities, and one thing to keep in mind is for the public housing, they'll have what's called an ACOP, which is their policy manual for public housing. They also have an administrative plan, which is their policy manual for Section 8. And so most housing authorities, a lot may have that online. If they don't, usually at their office, they have a copy that if needed, you could go look at or ask to see. And that has all the details of every part of the program, rent, calculating rent, all the way to evictions, terminations, and everything like that. It's a really valuable, good tool, especially if you're not sure exactly where to look to figure something out. It's got a great table. They have a great table of contents. They can point you exactly in the direction, and that's what the housing authority is generally following. So it's important to realize that does exist, and you can get it. Criminal activity that threatens, and kind of left that up there, but threatens usually health and safety or the right to peaceful enjoyment is what that is. So what that means is they have to show the criminal activity is not just any criminal activity. If you got a speeding ticket, technically the criminal activity, but is this criminal activity that threatens the health, safety, or right to peaceful enjoyment of other residents? That's what it has to get to in order for that to be essentially a good cause or a lease violation or serious violation. Other good cause, not during the initial lease term, but then other good cause is a little bit of a vague thing. And I haven't seen that come up too much where landlords have been successful in kind of pushing something to other good cause. But generally, other good cause is going to relate to if there's something else in state law that might say, hey, you can be evicted for this. One example might be not letting the landlord access the unit, refusing to let them enter to make repairs or something like that. The state law says you can't do that, so that might be something that comes into other good cause. So important differences we have here between Section 8 and the Residential Landlord Tenant Act is you're only paying the rent, and this kind of goes for public housing too, you're only paying the rent that you're supposed to be paying and the rent the housing authority has approved. So that what that really comes down to is no side payments. If the lease and and the housing authority says the rent for this unit is $1,000, the landlord can't say, okay, I know they said it's $1,000, but you got to give me an extra $200 on the side. So none of that. Tenant pays their approved portion. No rent increase during the first lease term. Any other rent increases has to be the housing authority's approval. HUD usually has the tenancy addendum, and that controls or wins if there's any dispute between that and the lease. Obviously, landlords can still evict for non-payment. They have to, of course, follow the rules on that, the notices on that. The housing authority also, as we mentioned, they can't abate that rent if they don't properly repair. And you can't evict, the landlord cannot evict from that non-payment by the housing authority. Tenant portion generally covers the services, maintenance, and appliances provided by the owner. The housing quality standards, so when you see HQS, that's housing quality standards. Again, SCRLTA, South Carolina Residential Landlord Tenant Act. And they might be more rigorous than the Landlord Tenant Act standards. Of course, the housing quality standards are going to be what controls in that. The lease terminates. If the HAP contract terminates, that's something important to remember. So if the housing authority is saying, you know, we're terminating this contract with the landlord, they'll usually give everyone a notice, tenant notice, say participant tenant, you now have X amount of time to find a new place to go. They can limit security deposits, but notices have to be in writing, and eviction by court action, and that, you know, really goes for any of the general private landlord tenant housing in South Carolina. Eviction has to be by court action. A landlord cannot help themselves in eviction. They can't try to get you to block you out or something like that. There's penalties for that. There's you know, laws that cover that, the Landlord Tenant Act. You know, the housing authority provides some minimal screening, but you may also, if you're going to private rental, you may have to get screened or whatever their normal screening process is for that private landlord. The landlord, of course, is responsible for the lease enforcement. The housing authority is going to focus on the requirements of the voucher itself. And one thing I will just mention, that project-based vouchers, you know, you're really dealing with project-based vouchers, you deal with the landlord that is kind of in the place of the housing authority, similar to how public housing would be. So you wouldn't have some of these other confusing or issues that can get confusing in that, as opposed to that triangle relationship, you with the housing authority and you with the landlord, when you have a housing choice voucher. So one thing here on this slide that we're talking about is you might hear sometimes a one strike rule or some type of thing like that. I think there's a lot of places that kind of confuse what that really is or what that really means exactly. So housing authorities, you know, they're allowed to exempt certain violent criminal activity and criminal drug activity from grievance process and the public housing authority plan. That does not mean that they can terminate a housing choice voucher without giving you an informal hearing to challenge it. They have to do that as a matter of due process, but it allows them to evict for a single or terminate a voucher for a single incident, as opposed to having to build up as far as minor violations. You know, there is no innocent tenant defense, and that's just referencing kind of a famous case, HUD v. Rucker, which basically said if the tenant doesn't know that their guest or someone else in their household is doing something wrong or committing this drug related or criminal activity, it doesn't matter. They can't say, well, I really didn't have any idea that my friend I invited over, Joe, you know, brought some drugs over and sold it to my neighbor. You still are subject to being evicted or a voucher terminated or something like that. You can't use that I didn't know as a defense. Some of them might have different rules about whether certain activity happens on or off the premises or on or near the premises, which that can be a distinction. You know, what does on or near the premises mean? Sometimes the housing authority might have in their policy manual, they might set out what they determine that means or what they view that to mean. Is it a few blocks away? Is it farther? You know, or something along those lines. So keep that in mind. And one thing that I would say is we did earlier this year get a decision in an appellate case that also talked about with evictions, and I probably will cover that maybe at next week's, talking about evictions in public housing or subsidized housing. But what essentially it does is housing authorities are supposed to use some level of discretion. What you'll see in the public housing, as I mentioned, 24.966.4 is really important. It usually sets out, and most of their policy manuals will set out what kind of discretion they'll use in deciding. You know, they look at whether they can evict somebody or terminate the voucher, but then looking at what they should consider as far as whether or not they should evict that person, or is there a way to maybe let them stay? And so oftentimes there are things to consider when you have these issues of criminal or drug related activity. But we won't get into too much of that, really go into that right now. That's kind of a longer discussion, and a discussion that can be kind of its own hour-long thing or more. So, but just wanted to hit on that. Let's know there is a little bit more to that story when you're seeing some of this. It's not just a one-strike rule, and they don't have, because one thing you'll commonly hear, public housing agencies or authorities, and sometimes even your project-based voucher owners and property managers will say, well, I don't have any control over it. We have to do it. And usually that's not true. They determine if they can do it, but they're also supposed to look at everybody's situation and determine is this a situation where they should do that. So this just mentions some other complexities. I won't get into it too much, but there's tax credit. Where you see LIHTC as low income housing tax credit regulations. So sometimes you might see things that are blended together of what can happen. Most of the time, what you're going to see at least that I find is a combination of project-based vouchers or public housing that also combines low income housing tax credit. And that's just a tax credit for low income housing that somebody's providing housing that is a lower rent than what the market is. And for providing that lower rent than what the market is, they get a tax break for that. They get tax relief. And so sometimes you'll see that as a combination. They might get the tax break and tax relief and also be a project-based voucher that gets subsidized by the government. In a LIHTC property, your rent is not changing whether or not your income changes. The rent is staying the same. It is just a lower than market rent. So sometimes you'll see those combinations. There's some others that aren't mentioned here that kind of are created, these subsidies that get created from other parts, but we won't really get into those. What I would say is always check the lease, because if you're not in public housing or you're not in project-based or you're not sure what you're in, a lot of times there's some information in the lease that can point you in the right direction. There's some other programs where I've seen the lease that will reference the regulation when they're talking about an eviction or a violation, and it will say as set out in 7 CFR XY or whatever, and that will usually be a good place to go to if you're not sure what kind of housing, if you're looking to figure out what kind of housing you're in, or if it's a particularly nuanced part of subsidized housing. All right, that really concludes really what we were going over today. Just kind of scratching the surface, so to speak, of what subsidized housing is, what subsidized housing, the common types to be aware of or to look for. So obviously we have a QR code here. If you have a topic or something you'd like to suggest or something that you'd like for us to speak on, then you can do that there with the QR code. We can leave that up for a minute or two for anybody that needs to scan that, and just let us know. I can bring it back in a minute if we need to.
That's great. Thanks so much, Matt. We'll go back to that in a minute so people have plenty of time to scan that QR code. And when you do, a form will come up and you can give information about yourself and the potential topic that you would like us to discuss on Level Up Law. What you're seeing right now is our contact information. We've got our intake line. They're open Monday through Friday, 9 to 6. Terrific people there taking your information when you apply for our legal assistance representation. And then, as I said at the beginning, you can also apply online, and that link is right there. You can also just go to our website, which is sclegal.org, and there's a clickable box right there that goes to online intake. We've also listed for you all of our resource locations. We have a lot of great legal resources, not just our episodes of Level Up Law like today, but a lot of other resources on our Law Help website, and also other things besides Level Up Law on our YouTube channel, our Facebook page. You'll just get all kinds of information. So definitely keep an eye on that. You can scan the QR code on this page, and we'll give a few more minutes on that, and that will give you an option to sign up for our newsletter, where we have a lot of good information as well. Well, I know that concludes Matt's presentation for today. So Attorney Matthew Billingsley, great presentation. We sure do appreciate you being here with us. And I do want to mention to our audience that Matt will also be with us next Tuesday to talk about eviction when it comes to federally subsidized housing. Touched on it a little bit today, but we'll get a little bit more detailed for our viewers and listeners. As always, we will post a recording of today's episode on our YouTube channel. Just look for that Level Up Law playlist on YouTube at SC Legal Services. And now remember, when you go to our YouTube page, share the video if you found it helpful, and if you think it may be helpful to someone else that you know. And while you're there, if you haven't subscribed to our YouTube channel, please do that as well. Sign up for notifications so you'll know every time we post a new video. And if you follow us on these social media sites, we're always posting the registration links there for our Level Up Law episodes, so do keep that in mind. We do want as many people as possible to get the information that we provide to you on Level Up Law. So some people may not need the information from today or other episodes, but you probably know someone who does. So please do share that out. I do want to thank again Matt Billingsley for today's presentation, and producer Kenneth Elliott, of course. And thanks to you, our audience. We truly do appreciate the loyalty to the show. And if you're in the YouTube replay and watching this, we appreciate you guys too. So thanks a lot. Now, I want to, before we conclude today's webinar, just remind everybody, of course, I want to thank Matt again for the presentation, and tell our viewers to please be sure and tune in next week for the second episode in this series on federally subsidized housing, when Matt will be discussing eviction from subsidized housing and how that works. So let's just remember that. And Matt, thanks so much. We really appreciate you being here. See you next week.
No problem. Next week.
All right. That concludes today's webinar. Thanks, everybody.